Hi everyone. I'm Aditya Shekhar. As you might or might not know me, I'm a part of Get Set Law, and here we are with yet another interesting session of Insight. Now, Insight is a series which basically shows you what exactly goes on in law universities. So here we are with another session of Insight. We have with us a very famous academician. His name is Dr. Balwinder Singh, and he is a assistant professor with UPES. He's done his LLM, LLB, and PhD from University of Jammu, and he will be basically teaching us the basics of family law. So, welcome to the show, sir.
Thank you, Aditya, and good evening, all. Hope you all are doing well. So let's start with this content that today what I am going to discuss with you. Since this is all about the family law, what my preference will be that I will give you a brief overview about family law. That is that what exactly the family law is, what are the areas which are being covered under this term family law. So how we distinguish family law into different, you can say, personal laws, because a terminology which is generally used for family law is personal laws also. So all these I will give you an introduction, or you can say an overview of all these topics. And before starting with this, I just want to know that how many of you are aware of like if it in general sense that law can be classified into different forms. So like when we talk about law, we generally say that law can be classified as procedural laws. It can be classified as substantial laws, and similarly, there is another category which generally talks about personal laws. So I will give you an introduction about the personal laws. Let me share with you a PPT for that purpose. Uh, Starting with this concept of family law. Generally, when we discuss about these things relating to the family law, a very pertinent question comes that what is the need of studying family law? So, like we are studying other laws, like law of crimes, you can say that law of contract, law of torts. What is the exact need of studying family law? See, when we discuss family law, we generally say that the life of an individual, it can be divided into two spheres, a private sphere and the public sphere. So the combination of both the spheres, public sphere as well as the private sphere, both will form a life of an individual. When we deal with public sphere, what are the kind of activities which are being dealt in the public sphere? So all are public dealings. For example, anything which is related to our job, employment, or anything which is related to how we actually act in a particular way. For example, the law of crimes, or you can say Indian Penal Code, all these aspects are covered under our public sphere. So if we say that we have to uh, be guided while riding a bike, we have to follow the traffic rules. So where these rules will be mentioned, these will be mentioned in the Motor Vehicle Act. Now, Motor Vehicle Act is a public law because it is dealing with our public issues. Similarly, when we talk about private sphere, all the issues which are very private to an individual, for example, marriage is a thing which is very private to an individual, like divorce, adoption, guardianship. Obviously, when a person dies, how his property is to be distributed to his heirs, all these things are very private to an individual. So every aspect that is being covered by the private sphere is being, you can say, it being guided by a law that is the personal laws or the family law. Now, you can ask me a question on this way that like why we are using this terminology personal laws. And because see, these personal laws, they are not dependent upon your domicile or your nationality. We can't say that person belong to such and such region, therefore he is having this personal law. Or we can't say that this individual is belonging to this state because he is a national of this state, he should have this personal law. Personal law is basically to the group you belong. So if you practice Hinduism, if you belong to Hindu religion, obviously you will be guided by Hindu law. If you are a Muslim, you will be guided by a Muslim law. Similarly, if you are a Christian, you will be guided by Christian law. And if you are a Parsi, you will be guided by the Parsi law. So these are the major, you can say, laws which are there. And owing to this, you can say, classification, which is only on the basis of a particular, you can say, a group to which you belong, we have given them the name of personal laws. Otherwise, the other name of these personal law is family law. So when we talk about family law, I will show you that these are the four kind of personal laws which are applicable in India. Majority, obviously, majority of people who are residing in India are Hindus, so majority portion is a Hindu law. Then comes the Muslim law. Christian and Parsi are like not, when we compare it with the Hindu or Muslim law, the population is not that much. So certain individuals are guided by the Parsi law also as well as the Christian law. Now, a question comes that there are certain individuals who follow Jainism. There are certain individuals who follow Sikhism. So we can't say that we have not written anything about the Jain religion or something relating to Sikhism. So who are they and how they are to be classified? So they will again form the part of Hindu law, because you all are aware of this fact that Jainism and Sikhism both emerged from Hindu law. So when we talk about law, the people who profess Sikhism, the people who profess Jainism, they will be guided by the Hindu law. Uh, Now, the question comes that what exactly are the component of these laws, these personal laws, or when we talk about family laws, and from where this family law originated? There must be some source from where this family law came. So if we talk about Hindu, from where our Hindu law came. So, what is the exact source of our Hindu law? We generally say that whatever has been written by the sages or whatever has been heard by the sages, that are the sources of Hindu law. So, we play a very much, you can say, our dependence is very much on our Vedas. You all know that four Vedas are there. We have certain Smritis also, that, for example, Manu Smriti is there and Narada Smriti is there. So these are ancient scriptures. So these ancient scriptures are also the source of Hindu law. Similarly, if we talk about Muslim law, Quran is the source of Muslim law. Similarly, we say that Sunnah is the source of Muslim law. Ijma, Qiyas, all these are the sources of Muslim law. So from the sources, there came different schools. Like for Hindus, we have two schools. For Muslims, we have two schools. Hindus, we have Mitakshara school, we have Deobhaga school. For Muslims, we have Shia schools, we have Sunni schools. So all these schools, they resulted into laws with different, you can say, modifications. So all this clubbed together form the part of family law. Now, if we talk about the sources, a very important source of all these personal law is a custom also. because once you see when we talk about family law, not every law has been codified. Only few parts of laws have been codified. For example, I will give you a thing like if we talk about Hindu joint family property, that law has not been codified. So during the codification process, when the Hindu Code Bill was brought into the Parliament in 1948, there was a strong resistance from the Orthodox section. Right now, if you talk about Muslim law, you see that whenever we are talking about uniform civil code, there is a strong resistance from the orthodox sections of Muslim law. Similarly, there was a strong resistance in the year 1948 also when we talk about the codification of Hindu law. The only plea was, since Hindu law is a divine law, they generally believe that God has given us Hindu law. So we can't intervene in it, we can't change our Hindu law. Similar plea is being taken by Muslims. Muslims are also saying this thing right now, that since this is a divine law, we can't intervene. Human intervention should not be possible. So this is the reason why Muslim community, in most Muslim community, is against the concept of uniform civil code. When we talked about Hindu law, I told you that there was a resistance at that time also, but slowly and steadily we codified Hindu law. We codified law relating to marriage and divorce. We codified the law relating to the succession. We codified the law relating to the adoption and guardianship. And we codified the law which is relating to the maintenance. So all these things have been codified. Codification brings or makes a law much more simpler, as well as that the differences between different schools, they are also being removed, and a uniform law is being applicable to all Hindus, whether they belong to Mitakshara school or whether they belong to Deyabhaga school. So this is just an example I am giving you about Hindu law. Now, a question comes that how and what is the method by which, like family law is you can say, is not a simple law, because when we deal with these four kind of different personal laws and they are clubbed together in like certain books, and they have generally divided family law into two parts, family law 1 and family law 2. And in many universities also, this course runs in this way also, that family law 1, and in the part of family law will 1 will be marriage, divorce, maintenance, adoption, guardianship. And this is with respect to other personal laws also. So marriage with respect to Hindu law, Muslim law, Christian and Parsi. Divorce similarly Hindu law, Muslim law, Christians and Parsis. Similar all other provisions are. So these topics are generally covered under family law 1. When we talk about family law 2, they generally talks about property law, property or succession, that how a property is to be divided, or when a person dies, how his property is to be distributed amongst the heirs. So all these things, for example, in Muslim law, there is a concept of gifts, which is also known as hiba. Preemption is there. Wills, both under Hindu law and Muslim law, we are now having the power to make a will. So all these issues form the part of family law too. Now, suppose I am a Hindu and I want to give property to my heirs. The first question will always be that whether I am having an ancestral property or whether I am having a separate property. So this is the first important question. Now, why this is a question for Hindu law? Because Hindu law makes a distinction between ancestral property, that is known as a joint family property, and a property that is separate property, the property which is owned by an individual. So, since these both the properties are having a different mode of devolution, so distinction is still relevant. And for your kind information, when I talked about codification of law, only the separate property law is being codified in Hindu law. The joint family property is still in the uncodified form. So if there is any issue from like relating to the joint family property, and this suit is being filed in the court of law, so how the judge will decide the law? Because we are not having a statute regarding the Hindu joint family. So the things are either the judge has to search those scriptures, and that has been written in the Sanskrit language and you have to translate it, or the thing is, like, you must have heard the term precedents, that the decisions which are given by the courts, they can be followed in the next decision, and provided the decision is given by the higher court. So a decision which is given by the higher court can be followed by the lower court. So on this basis, if there is any case which has been decided and that facts of the case are related to the new case which is present in the court right now, so if the facts are same, the answer is the decision should also be same. So this is the basis of either stare decisions or the precedent. So precedent can also be a source of Hindu law, but we classify precedent as a modern source of Hindu law. So this is how, through this example, you can see that there are peculiarities in these personal laws. And similarly, when we talk about Muslim law, how the property devolves under Muslim law. Muslim law, there is no concept of joint family property. Every property which is earned by a Muslim or which a Muslim is being is in possession of, it is generally devolved by intestate succession or testamentary succession. Intestate succession simply means that when a person dies without making a will, and testamentary succession means a person dies with a will. So if a person dies with a will, all his wishes are to be regarded. So the property will be distributed according to the wishes of the person. But what if a person dies without making a will? In that case, the situation is that the property will be devolved to the lawful heirs of that person according to the law. And for that, we have to look into the matter whether the property is separate property or the joint family property. And once we are able to recognize that this is a separate property, for that we have a law, Hindu Succession Act 1956. So these are the, I just gave you one example that how family law is being related to us and why we are calling it as a personal law. Similarly, when we talk about the other aspects, for example, you can see this slide, marriage. Whether it is a Hindu marriage, whether it is a Muslim marriage, whether it is a Christian marriage, uh, you will see that all these are processes of being solemnized, that how the marriage is being solemnized. In Hindu law, we have different ceremonies, and similarly in Muslim law, we have ceremonies, and in Christian law, we have ceremonies. So all these issues which are related to the marriage will also be the part of family law. So if a person wants to get married, for example, if a Hindu wants to get married to a female who is also a Hindu, for that, we are required to perform certain ceremonies. And if these ceremonies are not performed, we cannot say that marriage has been performed. So if these ceremonies are not being performed and a marriage is being solemnized, that marriage will be a void marriage. So ceremonies to marriage are very important. Similarly, when we talk about Muslim marriage, we say that Muslim marriage is a contract. There is an offer, there is an acceptance. And we generally say that the dower, which is being presented by the husband to the wife, or dower or meher, which is being provided, is a sort of a consideration. Similarly, Christian marriage follows different sets of rules. So all these issues which are related to the marriages are dealt with different personal laws. So if a Hindu wants to get married to a Hindu, for that we have Hindu law. If a Muslim wants to get married to a Muslim, we have Muslim law. If a Christian wants to marry a Christian, we have for that the Christian Marriage Act. But what if a Hindu wants to get married to a Muslim or a Christian? For that, whether we are having any law? Yes, we are having a law. That is Special Marriage Act. Special Marriage Act of 1954. So this Special Marriage Act of 1954 talks about like interreligious kind of marriages. So you must have seen or you must have watched like in Bollywood industries, many of the film stars they have married to their spouses are either of different religion or you can say that for example we take the example of Shah Rukh Khan or Gauri Khan. They have married under Special Marriage Act. Similarly, if we talk about the second aspect which is related to the marriage, because if a marriage has taken place, initially the classical concept according to Hindu law was that once a marriage has taken place, that marriage is a sacrament union, and there was a philosophy behind it that once you are married to a person, you will continue to get that person for 7 births. So that was a concept of Sat Janmo ke Sathi. So this was a concept that the marriage is a sacrament union. It is a permanent union. It cannot be dissolved. So the ancient Hindu law, you don't find this word divorce. But when we codified Hindu law, we introduced the terminology of divorce. And divorce is now a part of Hindu law. Similarly, in Muslims, divorce is there, and in Christians, again, the divorce is there. So once a marriage has taken place, the I'm not saying that in every case, but whenever there is an issue relating to the marriage, for example, there may be a case where a husband is being cruel to the wife or vice versa also, because we are living in a 21st century. We can't say that every time a male is going to be discriminatory or male is uh, having giving a cruelty to a female. It is a case where a female can also be cruel towards the male or the husband. In that case, you obviously want to get rid of the that spouse. So for that, what you require a law that can redress your grievance. For that, you will file a suit in the district court, and district court will give you a remedy that how you can get a divorce or get rid from that spouse. So we have different theories of divorce also. Like there can be a fault ground also, there can be irretrievable breakdown of theory. So all these grounds are there. So the second component which is closely related to marriage is divorce. So for that we have different laws. You must have heard about the concept of triple talaq, because this has been in controversy because in the case of Saira Banu versus Union of India of 2017, when this matter was raised before the Supreme Court, that where in Muslim law a person, especially a male, has been given a power to pronounce talaq and without assigning any reason to the wife, and not it is not essential that the person should be present in front of the wife. So if you text a message and write three times talak, 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 it is obviously a talak. So if you send an email in which you write three times talak, it was a talak. So it was not necessary that you have to be physically present for giving this talak. So all these issues were there, and we said that Muslim law is very discriminatory when we talk about this talaq, because as far as Hindu law is concerned, after the codification of Hindu law, now a husband and wife are having equal rights to get divorced. Moreover, the wife has been given four special grounds for divorce. But in Muslim law, you will see that the majority of these provisions are in favor of a male, and female is only given one remedy, that is talaq tafid, that has been delegated, that the power to pronounce talaq has been delegated to some near relative. So all these were causing hardships. So in this case of Shaira Bano versus Union of India, when the husband of Shaira Bano gave triple talaq to Shaira Bano, she raised this question in the court of law that this concept of triple talaq, this concept of nikah halala, and this concept of polygamy, which is still prevalent in Muslim law, all these are against the Article 14 and 21 of the Constitution. That is, they are against the right to life and personal liberty, including the right to dignity also, and right to equality. So, acting on this, the Supreme Court said that law, like triple talaq pronouncement, is not right. So the Supreme Court said that if anybody is going to give, any male is going to give talaq in this form, that at a moment you are saying talaq, 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 this talaq will not be operative. And this Supreme Court asked the center to frame a law on triple talaq, and as a result of which a new law was formed, that is Muslim Women Protection of Right on Marriage Act of 2019. So now if a person give a talaq to a female, that person will be put behind the bar, and the maximum punishment is 3 years, and he will be liable to fine also. So you have seen that there can be a cases where normally when we talk about marriage laws or these private sphere laws, we generally say that they are of civil nature. But when we codified this law that prevents triple talaq, we have also made this law, this pronouncing of triple talaq as an offense. So we have shifted it from the civil to the criminal kind of a thing. So this is the main contentious issue which has been raised by those Muslim sections that are against this law, that you have changed it from the civil to the criminal law. So why, if a person is giving divorce to the wife, why he is being treated as a criminal? So this is a point which where there is you can say a contentious issue has been raised by the Muslim men. But again, the Supreme Court said that uh, see, if we want to prohibit this kind of thing, and we generally say that uh, this can be an issue which can be sought out in a civil manner, so it is not possible, because after the coming into the force of this law, you have seen that still triple talaq is being practiced, even though it is being an offense right now. So if a husband is sitting in the Dubai and he pronounces triple talaq, so at that time this law will be applicable in India only, no? That person has to come back to India, then only he can be prosecuted. Otherwise, if he keep on residing in Dubai, he will never be prosecuted. So this is how we generally relate that how this issue has been covered by the family law or the different person laws. Similarly, there are issues which are relating to this maintenance, alimony, adoption, guardianship. All these issues are again the part of family law. So if marriage has taken place, after marriage a divorce has happened, now the third point will be maintenance, that if husband and wife gets divorced, whether the wife will get maintenance or whether the husband will also get maintenance. Normally when we say about maintenance, a question comes into our mind that usually the females need maintenance, but not like this. Hindu law has given an equal opportunity to the males also. So a husband can also claim maintenance from the wife, or the wife can also claim maintenance. And this maintenance provision will be operative only when the divorce has taken place. Adoption, again, a right to adopt a child. And this right was initially given to the husband only, but now a wife is also given the right of adoption. The only difference is that there should be an age gap of 21 years. For example, if a female wants to adopt a boy, the age difference between that female and the boy should be of 21 years. And similar is the case of a male. If a male wants to adopt a girl child, the age difference should be 21 years. So these are the certain issues which are being covered by the personal laws of an individual. Now, adoption, when we talk about Muslim law, you will see that adoption is not recognized under Muslim law. So under Muslim law, you can't adopt. You can only acknowledge a child. And that too when you know that this child doesn't belong to you or doesn't belong to some other person. So acknowledgement is a thing under Muslim law, but under Muslim law, there is no concept of adoption. Coming on to the Hindu joint family. So you can see that this is the structure of a Hindu joint family. Right now, there is often a question that Hindu joint family is at the verge of extinction, because right now people are more into individualistic kind of approaches, and moreover, the industrialization, the modernization has shifted our value system. So now the children don't want to live in a joint family; they all want to live independent. So whether it will be a case where the Hindu joint family will come to an extinction, the answer is no. Why I am saying the answer is no? It is due to the fact that you have seen that Hindu law has modified itself according to the changed circumstances. I will give you an example. Uh, Whether you have heard about a recent case of 2020, like Vinita Sharma versus Rakesh Sharma, where there was a question relating to the recent amendment. I will not say that recent amendment, but amendment in the Hindu Succession Act of in the year 2005, which made daughter also a co-partner. So what was the co-partner? Co-partner were initially the male members and who were having the right in the property of the Hindu joint family. So only the male members were having that right. No female was a co-partner. So daughter was not getting any right in the property if that property was ancestral property. Similarly, wife was not getting any right, or a sister was not getting any right. So you might have seen in your family also that if a partition has taken place, your aunts, for example, your buas, they have not got any right in the property if that property is an ancestral property, because the ancestral property was supposed to be distributed between the brothers or between the sons only. So this was again a discrimination which was there. And 2005 Amendment Act said that now daughter will also be a co-partner. by birth, a daughter can claim a right in the property, ancestral property. So there was a question regarding it, like whether this act will have a retrospective effect, that whether it will be applicable right from the beginning or it will be applicable only from 2005 onwards. And what if a daughter is born before 2005 or after 2005? Or what if a partition has taken place before 2005 or after 2005? So Supreme Court has very rightly said that once a daughter is always a daughter. So even if a daughter is born prior to 2005, but the partition has not taken place, she can claim a right because she is now a co-partner right from the birth. Even if the father is dead, then also she can claim a share from her brother. So this is how we can say that the Hindu law is continuously being modifying itself towards the changing socio-economic milieu. And this thing is not happening with Muslim law. As far as like my personal belief is, when we talk about Muslim law, we have seen that there are only piecemeal legislations that are actually acting for the betterment of a Muslim society. Otherwise, you will see that Muslim law is still governed by Quran. So the property has been distributed between like males and female in such a way that males are generally getting double share as compared to females. So son is generally under Muslim law gets a double share when we compare that son with the daughter. So this kind of discrimination is still prevalent in Muslim law, and for changing or for bringing a reform under Muslim law, what we require is generally the codification of law. And the codification of law is generally being assisted by the orthodox section. So this is the main reason why the important point of this uniform civil code is being, you can say, not linger on. It's not actually getting fruitful or getting any result. So this is generally interstate succession. I told you that when a person dies without making a will, there are different rules that govern this interstate succession under Hindu law, under Muslim law, Christian and Parsi laws. The next slide basically talks about testamentary succession. That what if a will is being made by a person? Now I will tell you that how a will in Hindu law is different from a will that is made under Muslim law. See, what happens that under Hindu law, a person, whether a male or female, they can make a will of whole of their property. So, if what if the like children are not treating the father rightly, father is having a right to make a will that he gives all his property in the name of charity, or if he gives all his property to some other relative. But when we talk about Muslim law, this is not possible because under Muslim law, one third is the rule, that only one third property of a Muslim can be given in the will. The remaining two-third property will follow the normal rule of succession, that is interstate succession. So this one-third rule is not there under Hindu law. So if a Muslim not being treated rightly by his family members, like his son is ignoring him, they are not providing him right kind of treatment, even then the Muslim is having that power that only one third property he can give to some other relative or in the name of charity. The remaining two-third property will obviously be devolving upon the heirs, whether those children are good children or virtuous children, or whether they are treating him badly. So in this way, that person can't help. Similarly, there is a concept of gift, and how gift and wills are different. See, for will, one person has to die. how a will operate only when the person who has made a will is dead. But gift is that you are giving something inter vivos, that both the things, the person who is making a gift and the person who is receiving a gift, they both are alive. So how a gift can be made under Hindu law, how the gift can be done under Muslim law, because under Muslim law, this gift has been given a different name, hibba. So all these are also dealt with the personal laws or the family laws. Similarly, there is a concept of preemption. Preemption is a very unique concept and it is applicable in Muslim law only. That when a Muslim person is about to, you can say, sail away the property in which he is residing, the first right to purchase that property is of his neighbor. So this is what the preemption is. That that a person will the neighbor will get his first right. This is again a traditional concept where it was said that no stranger should reside in your neighbor. So this is obviously you have seen that in this kind of a concept, the communities are living together so that no stranger can live there or they can interfere. Similarly, you must have seen this like Delhi Waqf Board, what exactly the Waqf is. So Waqf, again, the property which is given on in the name of God is known as Waqf, and the concept of Waqf is only under Muslim law. That when a person donates a property in the name of Waqf, that property will not be taken back. It can't be taken back by that person once it has been given in the name of God. So you have seen that there are many Waqf properties. Moreover, at one point of time, it was held that when a husband divorces his wife under Muslim law, and the wife has no means of earning, then who will maintain? It was said that the relatives of the wife will maintain, means the paternal side from the wife, or wife's father, mother, or brother, they have to maintain that wife. But what if they also are not having that capacity? Then the onus is upon the Waqf board. So Waqf board will maintain those all destitute kind of wives. So for that, it was said that this is something which is related to the charity. Now the Waqf is also doing some work of education. So education institutions are also being run under the Waqf. The last thing which we are going to cover is, you have seen that now the concept of family is getting changed. So we started with a concept where marriage was treated as a sacrament. From the sacrament, we came to that concept where we said that marriage can be dissolved by the help of divorce. So divorce was introduced. Now from there we shifted to the another level where we said that people don't require to get married to live together. So they opted for live-in relationships. So in live-in relationship, you don't have to undergo the formalities of, you can say, marriage. So being two adults, if you are living together, that is that you can be treated as husband and wife, even though you have not undergone the formalities of marriage. So this is again a new concept to, you can say, Indian society, that live-in concept. Moreover, from living, we are also moving into a stage where we have seen that in world, many countries in the world, they have recognized the concept of same-sex marriages. And recently, also 2 or 3 days before, there was a judgment which was passed by the court, that whether this same-sex kind of relations, whether they are viable for the Indian society, and the answer from the government was no, these are against our societal structure. So this is how the change is taking place. And the result of these changes are again the industrialization, the urbanization, the modernization, and the values, the traditional values are losing their grip. Again, when we talk about the other problems which a modern, you can say, a family is facing, like how is the division of labor being done within the family? That is it necessary that every household work is to be done by a wife? The husband has to earn only, or can either be a role reversible that husband can cook and wife can work? So what if a wife has sacrificed his her job for the needs of the husband, like in order to prepare food or to rear and bear the children of the husband? She has sacrificed the job. One fine day, husband comes and say that I don't want to live together, so I am pronouncing you the divorce. So at that point of time, whatever the contribution, not in terms of money, but whatever the contribution in terms of work, or you can say time, the wife has invested, like whether all those can be presented in the form of any amount or to the wife. So there is no answer for this question also. Then again, the concept is, if the wife has stopped earning, or for example if wife is still earning, and from the earning of the wife, she usually pays all the house rents or other bills, etc. And then one fine day husband pronounces divorce. So wife has spent all her earning in that house, and after that if husband asks her to move out of that house, that where that wife will get go. So all these issues, they are the changing patterns of the family. So our law has to be modified in such a way that all these issues, which we believe that these are futuristic kind of issues, that they will one or the other day they will come into the ambit of family law. So all these issues need to be addressed by making a proper law, either through the legislature or through certain cases in the judiciary, that a certain kind of guidelines are being given to the uh, government to frame such laws. So with this, uh, the discussion is over from my side. If any queries are there, you are free to ask.
Right, sir. So there are a few questions which students have asked while registering. So Meghalina from Bangalore asks, how is a Hindu marriage being a sacrament different from a Muslim marriage being a contract? So if you can throw some light on that, sir.
See, the question is very simple, that when we talk about Hindu marriage, we generally say that Hindu marriage at one point of time was treated as a sacrament. Because we generally believe that whenever the Hindu marriage was being performed, there were certain sacred ceremonies which were performed at the time of marriage. For example, there was a ceremony of Kanyadan which being performed. There was Saptapati, which is an essential ceremony being performed. So all these ceremonies were performed, and there were a recital of certain mantras also. And due to this thing, you will see that in our Shastras, there is nothing like divorce mentioned. So we believe that the marriage which is being solemnized in this one birth will continue till seven birth. So for that, we were against the concept of widow remarriages, because we can take it lightly. We say that that this female is reserved for that husband for seven lives. So if the husband dies, that female cannot marry with another person, because that will be the against the concept of the permanent union, indissoluble union, or sacramental union. Now, when we compare it with the Muslim law was simply a contract right from the beginning. that offer was being made from groom's side to the bride, and it was on the bride to accept. So you have seen that in the Muslim law, there is an thing like acceptance was required, and you have seen that the process of like Kabul hai, Kabul hai has been performed in Muslim law, but no such thing was being performed in Hindu law. So no consent of the bride was being taken. So this is what that essentials of contract, that the offer is being made, acceptance is being done from the other side and for a consideration. And what was that consideration? It was the meher or the dower amount, which was being paid by the husband to the wife. So in this way, Hindu marriage is still uh, considered as a sacrament by many, although we have introduced the concept of divorce after 1955 Hindu Marriage Act. But Muslim law, right from the beginning till now, is treated as a contract.
Right, sir. Another question is by Satish, a very interesting question. Even we are residing in 21st century, why is polygamy allowed for Muslim men in India?
So this is again a concept which has been mentioned in the Quran. See, why the polygamy was being was there in Islam, because you all know that this religion is basically these people, they took like uh, you can say that many wars have taken place, or they were always the in they took part in wars because it was considered as a holy war. The Islam was based upon the religion of like principle of holy war. So what happens that during these wars, many Muslim men got killed. So it resulted into a situation where in a village you can find only two men and 20 females. In order to protect the society from the harmful effect of prostitution or slave trade, it was said that a Muslim man can practice polygamy, like they can have many wives. So at least a respect is being given to those female, and which could not have been possible if this polygamy was not permitted, because it could have given rise to the evil prostitution. So for in order to protect them, the polygamy was being given. But again, I told you that whenever something good is being done, bad always find a place. So this concept of polygamy was not treated in a right way by the Mughal or the Muslim rulers. So they modified it accordingly. But the Prophet at one point of time, he said that we should restrict the number of wives. So in India, if polygamy is being permitted, that is restricted up to the four wives only. A Muslim male cannot have a fifth wife. If he gets a fifth, if he solemnizes marriage for the fifth time, it will always be considered as a voidable marriage. It is irregular kind of a marriage. It will not be a valid marriage. So this was the main reason why polygamy was being permitted. Even in Hindu law also, before 1955, polygamy was there. But after 1955, we said that monogamy will be the rule. So whoever is getting second wife, he is being prosecuted under section 494 and 495 of Indian Penal Code.
Right. Another question is there a concept of pre-marital agreement existing in India?
No, there is no such agreements in India. And even if these kinds of agreement are there, they will not be considered as valid agreements. Yes, there can be an agreement with respect to a Muslim marriage, where a wife can ask the husband before getting married that he will not take a second wife. So in that case,
Right.
this kind of an agreement can be allowed, but in other ways, uh, it is not allowed in every personal law.
Yeah. Uh, Partho asks, in Hindu law, if the wife dies if the Is the husband allowed to marry again?
After the death of the wife.
Yeah.
Yeah, like then again the you can say that the husband will be a single. So if he is
Right.
a single, he can marry again.
Right. Uh, okay. What are the considerations for child custody?
See, child custody, custody and guardianship are two different things. When we talk about custody, we generally say that the custody is given to the mother for a child who is a minor. So, minor, when a child is a minor, he will get the custody, whether he is a son or she is a daughter, the wife will be given the custody. But after attaining the age of like a few years of age, the another thing is like who will be the natural guardian of that child. The natural guardian of that child will always be father. And the other thing is the economic criteria, the lifestyle. If the wife is not having that economic capacity, there can be a question that whether it is essential to give custody of that child to the wife. So monetary consideration always plays a role. If the husband is in the better position, then in that case, the custody can be given to the husband also. But normally, when we are saying that an infant or a 2-year-old son, the custody is given to the wife.
Right. Right, sir. With that, I think we'll call it a session. It was lovely seeing you speak on family law, and you covered more or less every basics when it comes to family law. It was very informative, and it was very decently put out. So, just the last thing I would like to share what is there for you when it comes to GSL. So this, of course, was a part of Insight, which we had, the family law session, which we had. Upcoming Quizzard weekly law scoops Friday 9:30. We have fixed that time for Quizzard. Weekly law scoop Saturday at 8:30 p.m. Then we are coming with a judge on 6th of March, and then of course you will have SLAT form filling. So keep on watching us on YouTube, keep on subscribing to us, keep on watching these webinars. These are useful for you, and I hope we are able to make sense for you when it comes to your preparation and giving you that insight when it comes to law school education. So thank you so much, guys. You can also write down your feedback when it comes to this session. Please write down on the chat box how you felt about this lecture. Your feedback is extremely important, and we will try and incorporate whatever you suggest us, or whatever meaningful way we can engage you guys. So thank you, Balwinder Singh sir. It was lovely seeing you speak. It's always a pleasure to have professors from UPS come and take these sessions. So it was an amazing lecture, sir.
Thank you, Aditya. Thank you. Hopefully, I am able to convey to the students also the same thing. And
Right,
thank you once again, Aditya. Thank you.
right.
Okay.
All right, guys. Bye. Take care.